Dear graduates, and the Honorable David Waxse, President Don Gold, and Brian, family and friends. Today's a wonderful night. Today is a fun night. It's a night of celebration, or a day of celebration if you're on the West Coast, which is one of the great virtues of our technology that allow us to go coast to coast and indeed around the world. But today is the culmination of a long march. You have worked long days and long hours, and I dare say probably a lot harder than you had anticipated working when you began this program 7.5 months ago. You've made a lot of sacrifices along the way. You've canceled trips, postponed vacations, missed family events, paid less attention than you would have liked to important people and events in your life, and probably slept less than you had anticipated getting assignments in on time. But the good side is there have been many aha moments, and now I see moments where the truth and the foundations and the basis for e-discovery kind of resonated with you as you work through the anxieties and frustrations of 11 courses in our curriculum. Well, it's all at an end now. You've made it. Well done. We've completed this difficult and rigorous program in e-discovery project management. You and your families and friends have so much to be proud of. I'm so proud of you, and I know Gary, Brett, and President Don Gold are so proud of you as well. 7.5 months ago, you started on this journey across mountaintops with a sense of your own ability and a strong commitment. And you have traversed our courses showing ability, grace, and wonderful perseverance. For many of you, this was a new world, online, synchronous, collaborative learning. You had to master technology and adapt to a new learning model that challenges the boundaries of traditional education. Mastering the new, the novel, and change is not easy, but you did it. Our mission at Bryan University is to liberate the greatness in all our students and to provide new and exciting opportunities while addressing important social needs. Electronic discovery is more than a new field of endeavor. The health of our public dispute resolution system, our civil justice system, hangs in the balance. Our system of justice can only work if we have effective ways of getting to one thing, and that's the truth. The traditional truth-seeking methods of cross-examination and trial have served the country well over the past decades, if you will. And who can forget, for example, the great scene in the movie A Few Good Men, where Colonel Jessup screams, "You can't handle the truth," back to the cross-examiner, and then convicts himself with his own admissions. Great drama, great movie. We have our own great drama and great movie before us right now, because the 21st century brings a really new method of getting to the truth. And I submit to all of you an even better, more reliable method of cross-examination and human memory. Buried in the voluminous vaults of electronic information is that elusive truth that we seek in all our disputes. We just need to dig it out. We need to find it. We need to surface it. We need to bring it to the light of day. And that's what we've been doing, and that's what we've been focusing on here at Bryan University. How can we get those kernels, those important documents that clarify what's happening out in the world to see the light of day? The truth-seeking stage has just moved in our civil litigation process to a new locale, the locale of electronically stored information. Now we must cross-examine not merely witnesses at trial, but primarily the electronically stored information that surrounds our everyday activities and creates an ongoing record of virtually all human interaction and communication. You, our Bryan University graduates, are directors and actors of this new stage, skilled in new search and truth-seeking methods, an inhabitant of this new at home, in this new territory, this new ecosphere of digital information. You now have the skills and the understanding to bring the truth contained in digital data to light, to make the truth appear. And this, I submit, is no small thing. It's very important to all of us. Indeed, few things are that important. You all have been wonderful students. I've enjoyed each one of you. We at Brian know you'll be equally wonderful e-discovery professionals, and we look forward to following your careers. We look forward to your success. We want to keep in touch with you and want you always to think of yourselves as part of the Bryan University family. As your Dean, I extend to you my congratulations and wish you really enjoy this great day of celebration. It is now my great pleasure to introduce our guest this evening, United States Magistrate, the Honorable David J. Waxse. Judge Waxse is visiting us from Kansas, where he was a graduate of the University of Kansas. From there, he went to Columbia University in New York to obtain his doctoral degree. Before that, he was a partner at the well-known national law firm of Shook, Hardy, and Bacon, which some of you may recognize is also the home of our distinguished professor and faculty member, Denise Talbot. Before he went on the bench in the 90s, Judge Waxse was a member of the Kansas Commission on Judicial Qualifications, the State Judicial Discipline Organization. He was also a member of the Civil Justice Reform Act Advisory Committee and Mediation Panel of the United States District Court for the District of Kansas. Judge Waxse is past president of the Kansas Bar Association and was a delegate to the American Bar Association House of Delegates for a number of years. He served on the Professionalism Committee of the ABA and on the Board of Editors of the Professional Lawyer and ABA publication. He is past chair of the National Conference of Federal Trial Judges of the ABA and a member of the Ethics Committee of the Judicial Division of the ABA. Judge Waxse is also a fellow of the Kansas Bar Foundation and the American Bar Foundation. And he's also been involved in the community, not merely in bar activities. Before becoming a judge, he was a member of the national boards of the American Civil Liberties Union, the Lawyers Committee for Civil Rights under Law, and the American Judicial Society. He's also a member of the Judicial Conduct Advisory Committee of the AJS. And most interestingly for our purposes, Judge Waxse has been a lecturer at the University of Kansas School of Law and has made presentations on e-discovery nationally and internationally. And before Judge Waxse speaks, I'd also like to talk about his work on the bench that I know from my practice of law and also from my teaching at the University of Florida. Judge Waxse was truly an early pioneer on e-discovery. Judge Waxse probably doesn't remember it, but I met him for the first time at the Data Deluge conference that was held at Georgetown University some many years ago, probably 2006, 2007. And by that time, he was such a star that he'd already issued the case of Williams v. Sprint, United Management, which was a 2005 decision which clarified for all of us the role of metadata in litigation, and it really established a foundation that cleared up tremendous amounts of problems. And this, by the way, was before the federal rules came about talking about metadata. Judge Waxse has done has been issued very important decisions involving clawbacks and protection of privilege, most recently in the case of Rohalia versus Ethinex Energy, where he interpreted, I think, very correctly and accurately the Federal Rule of Evidence 502D that protected a company from a privilege waiver in that case. Judge Waxse, of course, has been involved in many think tanks, including the Sedona Conference. He's taught at Georgetown Law's Advanced E-Discovery Institute and published numerous articles and as well has spoken on many occasions. And I fondly recall speaking with him on one Sedona Conference event where we spoke about contemporary e-discovery events taking place a number of years back. So it's truly my pleasure as Dean, as your Dean, to welcome into our enclave and conclave, if you would, Judge David Waxse, a true e-discovery pioneer, a true scholar, a man of the community, and a man of the bar. So without further ado, Judge Waxse, the floor is yours.
Thank you, and thanks for the invitation to speak at your commencement. I want to congratulate all the graduates on your success in completing the e-discovery project management program. As a federal magistrate judge, I've seen numerous situations where I wish someone on the litigants team had the kind of competence you have now developed. In addition to competence in e-discovery, I think you should also try and focus on the purpose of the litigation system you'll be working in. As I'm sure you recognize, the purpose is to resolve disputes in a just, speedy, and inexpensive manner. Right now, Rule 1 of the Federal Rules of Civil Procedure says that the courts should administer the system in a manner to secure that goal. As you may know, in 2010, the federal courts convened a conference of lawyers, judges, and law professors at Duke Law School to first determine if the judicial system was meeting its goal of just, speedy, and inexpensive determinations. After concluding that we were not meeting that goal, many suggestions were made on how to improve the system. Although there were suggestions for changes in the Federal Rules of Civil Procedure that are now being considered by the Civil Rules Advisory Committee, there was no clear consensus on any specific changes other than the one relating to Rule 1. And I and many others suggested that that rule be changed to make clear what is now implied, that everyone in the litigation system has the same obligation to secure the just, speedy, and inexpensive determination of the case. In other words, it's not just the court's responsibility, it will be counsel's responsibility also. The question remains, though, how do we do that? Among the areas the participants of the Duke Conference discussed were increased judicial involvement in case management and the use of sanctions for improper behavior. The suggestion I made, along with many others, was to encourage cooperation in the discovery process, a suggestion that did become a consensus recommendation. So I want to talk about a little bit tonight about what is cooperation and why will it work as a solution to the problem of increased cost and delay in litigation. To start from the very simple, according to the Merriam-Webster Dictionary, cooperation is the act of cooperating, and cooperating is to act together with another for mutual benefit. There are numerous references to cooperation in many interdisciplinary fields of systems analysis and social science and brain research. All that research shows that cooperation is something that can be taught and that cultural mechanisms help develop cooperation. That understanding helped the Sedona Conference develop the Cooperation Proclamation in 2008. That proclamation, if you haven't read it, can be found in full on their website, which is simply the sedonaconference.org. The Cooperation Proclamation starts with this statement: the cost associated with adversarial conduct and pretrial discovery have become a serious burden to the American judicial system, and this burden rises significantly in the discovery of electronically stored information. The Cooperation Proclamation acknowledges that what is required is a paradigm shift in the discovery process. The first question, though, we have to answer to get to that paradigm shift is, how can cooperation exist in an adversary system where each lawyer has a duty of zealous advocacy? Canon 7 of the ABA Model Code of Professional Responsibility stated, a lawyer should represent a client zealously within the bounds of the law. So the first question is, why should non-lawyers care about these ethical issues? As you may have learned already, Rule 5.3 of the Model Rules, which have been adopted by most states, has a provision on responsibilities regarding non-lawyer assistance. And it's important enough, I want to read you the language. It says, with respect to a non-lawyer employed or retained by or associated with a lawyer. Obviously, that's the role you'll be playing in the litigation system. The rule goes on to say a partner and a lawyer who individually or together with other lawyers possess comparable managerial authority shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that any person doing this kind of work is following these rules. A lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure the person's conduct is compatible with the lawyer's obligations. A lawyer shall be responsible for conduct of such a person that would be a violation of the rules of professional conduct if engaged in by the lawyer. So with that rule, it becomes very important for non-lawyers like you graduates to make sure you understand what the rules are and comply with them, because you can have serious effects on the lawyer you're working with or for. So that's why you should care. But let's go back to where I started in terms of zealous advocacy. The thing that I think too many lawyers and their helpers forget is that when the ABA Model Rules of Professional Conduct replaced the code in 1983, they took out this obligation of zealous advocacy. In the current version of the Model Rules of Professional Conduct, that explicit obligation of zealous advocacy does not exist. With there no longer existing an ethical obligation of zealous advocacy, the Sedona Conference provided the following guidance in its outside litigator proposals. Litigators are expected and ethically required to be advocates for their clients. They are also expected and ethically required to conduct discovery in a diligent, efficient, and candid manner. The tone of a case is usually set at the beginning, so it's important for all counsel to abide by and advance the principles of cooperative discovery at the onset of the case. Following the creation of the Cooperation Proclamation, many courts have now written opinions urging counsel and anybody working with counsel to be cooperative. For example, Judge Grimm, who spoke to an earlier commencement at your school, in a case captioned Mancia versus Mayflower Textile, wrote, "Although judges, scholars, and commentators themselves long have recognized the problems associated with abusive discovery, what has been missing is a thoughtful means to engage all the stakeholders in the litigation process, lawyers, judges, and the public at large, and provide them with the encouragement, means, and incentive to approach discovery in a different way." In an opinion I wrote a couple years ago in Gibson versus Southwestern Bell Telephone Company, I stated, as of the date of the discovery conference, more than 115 motions and 462 docket entries have been filed in this case. Many of the motions filed have addressed matters that the court would have expected the parties to be able to resolve without judicial involvement. This court's goal, in accordance with Rule 1, is to administer the federal rules in a just, speedy, and inexpensive manner. To assist the court in accomplishing this goal, the parties are encouraged to resolve discovery and other pretrial issues without the court's involvement. To help the parties and counsel understand their discovery obligation, counsel are directed to read the Sedona Conference Cooperation Proclamation. Following up on that kind of opinion, another technique I have been using is to have what I call Mancia hearings. That's that case I just referred you to that Judge Grimm wrote. When a case becomes bogged down with numerous discovery disputes, I set the matter for hearing in the courtroom and start the hearing by giving each counsel a copy of Judge Grimm's opinion in Mancia. And I tell them that I'm assuming you haven't read this opinion because I've witnessed the behavior I have in the discovery disputes. And I explain to them that this opinion revitalizes Rule 26G of the Federal Rules of Civil Procedure. And in case you haven't run into that in your studies, let me give you some of the language of 26G, because it's one of the most underutilized provisions of the rule that's going to have to be more utilized if we're going to get to just, speedy, and inexpensive. What 26G is a requirement that any discovery request or response be signed, and the signature of the attorney, or if it's a pro se litigant, must not only give their address and name and phone number and all that, it is a certification that to the best of that person's knowledge and belief formed after a reasonable inquiry that with respect to a disclosure, it is complete and correct, and with respect to a discovery request, response, or objection, it is consistent with the rules and warranted by existing law or by non-frivolous argument for extending existing law, and is not interposed for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation, and that either the request or the response is neither unreasonable, unduly burdensome, expensive, considering the needs of the case, and the rule goes on to provide that if any of these things occur in the discovery process, and listen carefully to this part of the rule, if a certification violates this rule without substantial justification, the court on motion or on its own must impose an appropriate sanction on the signer or the party on whose behalf the signer was acting, or both. This sanction may include an order to pay the reasonable attorney's fees caused by the violation. So back to my Mancia hearings, what I tell them then is that I've reviewed your pleadings, and it appears to me there are numerous violations of 26G. And I explained to them that I have made an initial determination that a $1,000 sanction for each violation is appropriate unless they can convince me otherwise. I then explained to them, though, that I'm going to give them a chance to see if they can cooperate and resolve these problems without me sanctioning anyone. I also point out that, contrary to what most people think, every federal courtroom has cameras in use in the courtroom for security purposes. And I've made arrangements with our United States Marshal's Office to be sent a digital copy of the video if I need to review it. And then I explain to the lawyers that are in the courtroom that they can either resolve their discovery problems on their own, or when they tell me they're unable to do so, I'll just watch the video and determine what my rulings will be on these sanctions. The amazing thing is I have yet to have to rule on any of the motions when I've handled them this way. I used to say I don't understand why this works, but I was on a panel earlier with a lawyer who has an undergraduate degree in physics. He explained he understood why it works. He said, lawyers are like particles in physics. They change when observed. So why is cooperation not happening often enough, and what can be done to increase cooperation? I think there are numerous reasons why cooperation is not often happening. One is the misconception that I've already discussed, that lawyers have an ethical obligation of zealous advocacy, which then justifies all kinds of obnoxious behavior in discovery. Another reason that you have to recognize is that lawyers who become litigators often have personalities that love conflict and competition. So it's not... Steve, my screen went blank. I will keep talking even though I can't see you all. There. Okay. Another reason often not discussed is that hourly billing systems used by many law firms create an incentive to engage in conflict instead of an incentive to cooperate. And finally, too many people involved in the litigation system, whether it's attorneys or non-lawyer persons helping attorneys, have what I think are not the correct goals. Some people are involved for purely economic reasons. They want to maximize their income without regard to the impact on the system or to their clients. So what can courts and everyone involved in the litigation system do to increase cooperation in the process and thus reach the goal of a just, speedy, and inexpensive determination of the case? The first step is we've got to get an agreement that the reason we litigate the way we do is we're trying to reach just, speedy, and inexpensive. The litigation system does not exist for lawyers to play games about who's winning this lawsuit or for lawyers to try and maximize their income. What we're trying to do is in a civil manner, resolve disputes in a just, speedy, and inexpensive way. So how do we do that? The next step is to actually follow the rules that exist, and in situations where the rules are not being followed, to enforce them. Finally, I think it may be helpful for some participants in the system to be reminded that cooperation is something they should have learned in school, and it's never too late to learn how to cooperate. For those who can't seem to learn to cooperate, I found a list on a website for elementary school teachers that I've now been handing out to some of these lawyers that need a little extra help. And that list says, these are some steps you can take to be a cooperative person. 1, listen carefully to others and be sure you understand what they're saying. 2, share when you have something that others would like to have. 3, take turns when there is something that nobody wants to do and when more than one person wants to do the same thing. 4, compromise when you have a serious conflict. 5, do your part to be the very best you possibly can. This will inspire others to do the same. My ending point is it's never too late to learn how to cooperate, even if you're now involved in e-discovery litigation in federal court. So congratulations again, and please keep these thoughts about cooperation in mind as you become part of the litigation process. Thank you.
Thank you very much, Judge Waxse. It was fun to hear your, unfortunately, too accurate description of some of the conduct that all of us have experienced that have been in the litigation process for some time. I'd like to point out that since my opening, we have some professors at Bryan University that have joined us. Professor Talbot is with us. Also, Professor Nevin is with us, and Professor Axelrod. And I thank them for joining us and being part of this celebration tonight. I'd also like at this point to let you know we're going to be sending you a little memorial plaque, if you will, for your participation tonight. I'd like to read it to you. You'll be receiving it by appropriate delivery service, but it says, Bryan University presents the Honorable David J. Waxse this token of appreciation for his presentation at the commencement address of the graduating class of August 2012 in the Bryan University e-discovery project management program, and for your work and dedication in the advancement of e-discovery education. And I thank you very much for being with us tonight, and thank you deeply for all you have done for e-discovery. And we shall take your words of cooperation seriously as we go forth, as well as some of the more interesting points you've made that will reside with me, such as the Insia moment, which is one of my favorite cases from Judge Grimm, and also the notion that attorneys change when being observed. Unfortunately, how true. Again, thank you very much, Judge Waxse.